So what happens then after the judge makes that invitation?
So this is where it gets interesting. So what happens after that is if the parties have agreed to go to mediation, there'll be an adjournment, whatever, to facilitate this. And then the ball or the buck passes to the mediator. Because under Section 17, a mediator has to prepare a report to go back to the court in the case of a court referred mediation. Okay. Now, this has really been the most controversial aspect of the whole act to date. And you see it particularly when we look at the provision on cost penalties in a minute. So originally, the mediator's reporting duties were even more extensive when they are than they are now. But even still, what a mediator has to do is make a report after this back to the court to state whether or not the mediation took place. Okay, where it did not take place, a statement as to the reasons why it didn't take place, and where it did take place, a statement as to whether or not settlement was reached, and if settlement was reached on some or on all matters, a statement of those terms of settlement. Okay, so basically the way this was kind of sold, if you like, during the legislative process was that the court wants something back if they make a referral to mediation. Okay, obviously this now puts a burden on the mediator to report back and say, well, judge, the mediation didn't take place because the parties didn't turn up. One party refused to engage. They settled, they didn't settle. Interestingly enough, in a previous draft, in the original draft bill, there was an additional obligation to report in this, where the mediator was obliged to report on whether the parties had engaged fully in the mediation process. And after, of course, significant lobbying by various mediation organisations saying this is just totally unworkable, how on earth are we meant to define full engagement and what are the implications of this, that provision was removed. But this is still an onerous obligation because the recent court rules that have been drafted now to deal with the practical implementation of this act have set out that the mediator must make this report in writing and must attach a copy of the report to an affidavit, which is a sworn statement to the court. So that opens the door for the mediator being called to give evidence on the content of this report. And that all gets even more interesting when you look at the provisions on fees and costs and the orders that the court can make in relation to fees and costs.
Okay, and what about confidentiality in all of this?
Well, exactly. This is already a provision that abridges the confidentiality that is set out in Section 10, because, if a mediator is going to make a statement, a report around whether or not the mediation went ahead and what the matters were that were settled in it, that already erodes the confidentiality somewhat. And that is obviously a cause for concern.